My brother's drunken confession got me convicted for 9 years, and now the truth is coming for him. The prison counselor's words barely registered over the sound of my own heartbeat. Your brother's here for visitation. He says it's urgent. 9 years. I'd spent 9 years behind these concrete walls because of what my brother told the police one drunk night after our father's funeral, and now he wanted to talk urgently. I almost laughed at the absurdity of it. The irony of Ethan showing up now, 3 weeks before my parole hearing, felt like the universe's idea of a sick joke. Officer Dennis Kowalski, a man who'd worked corrections for 23 years and had seen every manipulation tactic inmates could devise, walked me to the visitation room with an expression that suggested he knew something I didn't. The fluorescent lights hummed overhead, that institutional buzz that had become the soundtrack to my 30s. Ethan sat at table 7, his hands folded like he was praying, wearing an expensive suit that probably cost more than I'd earned in my last year of freedom. His face had aged badly for 32. Deep lines around his eyes, a softness around his jaw that spoke of too much good living and not enough consequences. He looked up when I sat down, and I saw something in his expression that made my chest tighten. Guilt. Real, raw, eating him alive guilt. Not the performative kind he'd shown at my sentencing. Not the tearful apologies he'd written in letters I'd never opened. This was different. This was fear, dressed up as remorse. He opened his mouth to speak, and I held up my hand to stop him. Whatever you came here to say, I don't want to hear it. My voice came out rougher than I'd intended, 9 years of disuse making normal conversation feel foreign. Ethan's face crumpled, and he said my name like it hurt to speak. Jordan, I need to tell you something. I can't live with it anymore. The visiting room suddenly felt smaller, the walls pressing in like they'd been doing since the day I arrived at Danvers Correctional Facility. I leaned back in my chair and crossed my arms, watching my younger brother fall apart across a scratched plastic table, while families around us tried to maintain some semblance of normalcy in an inherently abnormal situation. I'd been working as a forensic accountant for a mid-sized firm in the city when everything fell apart. My job involved tracking financial irregularities for corporate clients, finding the paper trails that proved embezzlement, fraud, and money laundering. I was good at it. Meticulous, patient, and skeptical enough to question assumptions that others took for granted. Those same qualities that made me successful professionally would later make my conviction feel particularly cruel. I knew how investigations worked. I understood evidence chains and documentation requirements, and yet none of that knowledge had saved me when the system decided I was guilty. My father had died suddenly of a heart attack at 61, leaving behind a modest estate and 2 sons with complicated relationships. Ethan was the golden child, charismatic and charming, but perpetually struggling with money, relationships, and taking responsibility for his choices. I was the responsible one, the steady son who'd built a career and bought a house and did everything right according to the script we're all handed. Our father's wake had turned into a disaster when Ethan got spectacularly drunk and started picking fights with relatives about inheritance. I'd driven him home that night, gotten him into his apartment, and left him passed out on his couch. 2 days later, police showed up at my office with questions about a hit and run that had killed a college student named Amy Thornton. She'd been crossing the street near campus at 11:30 p.m. when a dark sedan had struck her and fled the scene. Witnesses reported a partial plate that matched my car. I'd explained that my car had been parked at my house all night. I'd been home alone after the wake, exhausted and grieving. I had no alibi beyond my own word, but I also had no reason to be anywhere near campus. The police seemed satisfied initially. Detective Lawrence Chen took my statement and said they'd continue investigating. Then Ethan gave his statement. According to the report I'd read during discovery, my brother had told police that I'd seemed agitated the night of the wake, that I'd been drinking heavily, that I'd said something about needing to clear my head with a drive. He'd told them I'd returned to pick him up from his apartment around midnight, seeming shaken and asking him not to mention I'd been out. None of it was true, but Ethan's statement, combined with the partial plate match and lack of alibi, was enough for prosecutors to build a case. The trial lasted 3 weeks and destroyed everything I'd built. My court-appointed attorney, a overworked public defender named Neil Granger, who'd been practicing for 11 years, did his best with limited resources and an unsympathetic jury. The prosecution presented Ethan's testimony as the key evidence. My own brother, tearful and reluctant, explaining that he'd tried to protect me but couldn't live with the lie anymore. He described how I'd confessed to him that night, how I'd begged him to stay quiet, how the guilt had eaten away at him until he'd finally come forward. The jury believed him. Why wouldn't they? What brother would lie about something so serious? What motive could Ethan possibly have to falsely accuse his own sibling? The prosecution painted me as a man who'd been drinking, who'd made a terrible mistake, and who'd tried to use family loyalty to escape responsibility. They emphasized my lack of alibi and the witness descriptions that broadly matched my car. They brought in accident reconstruction experts who testified that the damage patterns on my vehicle were consistent with the collision. I maintained my innocence throughout, insisting I'd been home alone, that my car had never left my driveway that night. But my defense crumbled against Ethan's testimony and the physical evidence. The jury deliberated for 16 hours before returning with a guilty verdict on vehicular manslaughter and leaving the scene of an accident. The judge sentenced me to 12 years with possibility of parole after 9. Amy Thornton's mother gave a victim impact statement that broke something inside me. She described her daughter's dreams of becoming a teacher, her volunteer work with literacy programs, her kindness to everyone she met. Mrs. Thornton looked directly at me and asked why I'd stolen her daughter's future. I wanted to scream that I hadn't done it, that I'd never even been to that part of the city that night, that my own brother had destroyed both our lives with his lies. But the time for protests was over. The system had decided I was guilty, and nothing I said would change that reality. My first year at Danvers was survival mode, learning the rhythms of institutional life, figuring out which guards were reasonable and which ones enjoyed their power too much, navigating the complex social hierarchies among inmates. I kept to myself mostly, spent my time in the library reading case law and filing appeals that went nowhere. My attorney had warned me that wrongful conviction cases rarely succeeded without new evidence, and what new evidence could possibly emerge? The crime scene had been processed, witnesses interviewed, physical evidence cataloged. Unless someone came forward with information that contradicted the official narrative, I was stuck serving my sentence for a crime I didn't commit. Ethan visited exactly once during my first year inside. He showed up looking haunted, said he was sorry about how things had turned out, that he'd just been trying to help the investigation by being honest about what he remembered. The gaslighting was so smooth I almost missed it. He'd repositioned his lies as confused memories, his betrayal as civic duty. I told him to leave and never come back. He'd tried writing letters after that, long, rambling apologies that never quite acknowledged what he'd actually done, just expressed regret about the situation we'd found ourselves in, as if my conviction was something that had happened to both of us, rather than something he'd caused. I burned the letters without reading past the first few lines. The outside world continued without me. I lost my job, obviously, and then my house when I couldn't pay the mortgage from prison. My savings disappeared into legal fees and property taxes. Friends stopped visiting after the first few months, their discomfort with my incarceration outweighing whatever loyalty they'd felt. My mother visited monthly, her face growing older and sadder each time, never quite able to reconcile how both her sons had ended up on opposite sides of this nightmare. She believed I was innocent, but she also couldn't believe Ethan would lie about something so serious. The cognitive dissonance was destroying her. Meanwhile, Ethan's life seemed to improve in direct proportion to my decline. I heard updates through my mother's careful mentions and through social media screenshots other inmates showed me for reasons I never fully understood. Ethan had gotten a job in sales at a pharmaceutical company, quickly climbing the ranks through the same charm that had convinced a jury of my guilt. He'd gotten engaged to a woman named Claire, bought a condo in a trendy neighborhood, posted photos of exotic vacations and expensive dinners. He'd built a life on the foundation of my destroyed one, and the injustice of it burned hotter than any anger I'd experienced before incarceration. The appeal process was brutal and ultimately pointless. My new attorney, a woman named Judith Blackwell who specialized in wrongful conviction cases, reviewed everything and found no grounds for overturning the verdict. The trial had been conducted properly from a procedural standpoint. The evidence had been sufficient for conviction. Ethan's testimony was credible and consistent. Without proof that he'd lied or that exculpatory evidence had been withheld, we had no basis for appeal. Judith explained this with professional sympathy while charging my mother $15,000 for her review. The money disappeared into the legal system's endless appetite for fees, and I remained exactly where I'd started. Prison changes people in ways that are impossible to explain to anyone who hasn't experienced it. The constant noise, the complete lack of privacy, the casual violence that erupts without warning, the institutional food that all tastes like variations on cardboard and salt. You learn to sleep with one eye open, to eat quickly, to move through spaces with awareness of everyone around you. You learn which conversations to avoid and which alliances to maintain. You develop hypervigilance that becomes second nature, always assessing threats and calculating responses. I spent my time working in the prison library, a position that kept me away from the worst of the general population drama and gave me access to legal resources. The librarian, a civilian employee named Rita Kowalski, who'd worked at Danvers for 18 years, took interest in my case after seeing me pore through law books for months. She asked questions about my conviction, listened to my story, and said something that stuck with me. Innocent people don't usually stop fighting this hard. I'd laughed bitterly and told her that fighting required hope, and hope was a luxury I couldn't afford. But Rita was persistent. She started bringing me articles about wrongful convictions, about cases that had been overturned years or even decades later when new evidence emerged or witnesses recanted. She pointed out patterns in false testimony cases, explaining that liars often revealed themselves eventually through inconsistencies or guilt. She suggested I document everything I could remember about that night, about Ethan's behavior, about the investigation. I started writing it all down, filling notebooks with memories and timelines and questions that nobody had bothered asking during the trial. The exercise felt pointless at first, like screaming into a void that would never echo back. But the process of organizing my thoughts revealed details I'd forgotten or dismissed. Ethan's aggressive drinking at the wake had been unusual even for him. His arguments with relatives had focused specifically on inheritance money he claimed he was owed. His mood had shifted from belligerent to terrified when I'd driven him home, asking repeatedly if I thought he'd said anything embarrassing, if people would remember his behavior. At the time, I'd attributed it to drunk anxiety. In retrospect, the fear seemed disproportionate to the situation. I wrote down everything I could recall about the 2 days between the wake and the police interview. Ethan had called me 6 times that first day, asking strange questions about my whereabouts and whether I'd talked to anyone about the wake. He'd seemed relieved when I said I'd been home alone, that I had no plans to discuss family business with outsiders. The second day, his calls had stopped completely. Then police had arrived at my office with their questions, and my life had ended. Year 3 brought an unexpected development through the prison grapevine. An inmate named Darius Webb, serving time for multiple DUIs, mentioned during a library conversation that he'd known someone who'd been involved in a hit-and-run near the university around the same time as my case. He didn't have details, just remembered his cousin talking about some rich kid who'd hit someone and had family money to make it disappear. I pressed for more information, and Darius said his cousin had died of an overdose 2 years ago, but the rich kid might have been someone named Austin or Ethan or something like that. The name hit like a physical blow. I asked Darius if he could remember anything else. He shrugged and said his cousin had been unreliable and probably exaggerating anyway. Rich kids were always getting away with things, but the seed was planted. I told Rita about the conversation, and she looked at me with an expression I couldn't quite read. She asked if I'd ever considered that my brother might have been the actual driver. The thought had occurred to me in abstract terms, but I'd always dismissed it as paranoid desperation. Surely Ethan wouldn't have let me go to prison for his crime. Surely the guilt would have broken him. Rita pointed out that people were capable of extraordinary self-deception when the alternative was accountability. She suggested I try to find out more about Ethan's whereabouts that night, about whether he'd had access to a car, about his financial situation around the time of the incident. The problem was that I had no resources to investigate from inside prison. No internet access, no phone privileges beyond brief monitored calls, no ability to travel or interview witnesses. I was completely dependent on outside help, and the only person who visited regularly was my mother, who was barely holding herself together. I started making lists of questions I needed answered, information I needed gathered, connections I needed made. The lists grew longer and more detailed, consuming notebooks that Rita kept supplying. I became obsessed with the idea that Ethan had not just lied to protect himself from difficult questions, but had actively framed me for his own crime. The theory explained so many inconsistencies that had bothered me about the case. The prosecution had made a big deal about damage on my car that supposedly matched the collision. But I'd never seen that damage before my arrest. My car had been in perfect condition when I'd parked it that night. What if someone had damaged it deliberately to create evidence? What if Ethan had access to my spare key and had used my car specifically to implicate me? The thought made me physically ill, but it also made terrible sense. Year 4 brought my mother's decline. She'd been diagnosed with early-onset Alzheimer's, the stress of the past years accelerating a genetic condition that had taken her own mother. Her visits became confused and repetitive, asking me the same questions multiple times, forgetting conversations we'd had minutes earlier. Ethan took over her care arrangements, moving her into a facility near his condo, posting photos on social media about being a devoted son during difficult times. The optics were perfect. He was the good brother, sacrificing to care for their ailing mother while I sat in prison for vehicular manslaughter. Nobody mentioned that his devotion had only kicked in after my incarceration made me unavailable. Nobody questioned why he'd suddenly become so involved after years of casual neglect. My mother's decline meant losing my only consistent visitor and my only connection to outside information. Rita tried to help by looking up public records and news articles during her lunch breaks, but her access was limited and her time constrained. I felt like I was drowning in concrete, every year adding another layer between me and the truth I couldn't reach. Then Year 5 brought an unlikely ally through Rita's persistence. She'd been telling her husband, Officer Dennis Kowalski, about my case during their dinners. Dennis had initially dismissed it as typical inmate denial, but Rita's conviction in my innocence had worn him down. He'd started looking into the case file himself out of curiosity, using his law enforcement connections to pull the original investigation records. What he'd found had troubled him enough to bring it up with a former colleague who'd become a private investigator. Lawrence Boone had spent 26 years as a detective before retiring to run his own investigation firm, specializing in cold cases and wrongful convictions. He'd agreed to review my case pro bono after Dennis explained the inconsistencies he'd noticed. The original investigation had been remarkably surface level for a fatal hit and run. Witness interviews were brief and leading. Physical evidence had been processed quickly without thorough documentation. The damage assessment on my car had been conducted by a single technician whose notes were sparse and included no photographs. Most damning, nobody had interviewed Ethan a second time after his initial statement, despite the fact that he'd been the only person claiming to have information about my supposed confession. Lawrence visited me in Year 6, a silver-haired man with sharp eyes and a notebook full of questions. He walked through my entire timeline of that night, asking for details I'd forgotten, and some I'd never considered important. Where exactly had I parked at Ethan's apartment? What time had I arrived and departed? Had I noticed any other cars in the lot? What had Ethan been wearing? Had he had any injuries or seemed physically affected beyond his drunkenness? I answered everything I could remember, watching Lawrence take notes in precise handwriting that reminded me of my own work, documenting financial irregularities. When I mentioned that Ethan had seemed unusually agitated beyond normal drunk behavior, Lawrence looked up sharply and asked what I meant. I described how Ethan had been clutching his side and limping slightly when I'd helped him into his apartment. At the time, I'd assumed he'd stumbled during his drunken arguments at the wake. Lawrence asked if I'd noticed any damage to Ethan's car. I said I hadn't seen Ethan's car that night, which had struck me as odd since he normally drove everywhere. Lawrence made a note that he underlined twice. The investigation Lawrence conducted over the next 18 months was methodical and devastating. He started by tracking down the original witnesses who'd reported the hit and run. 3 college students walking home from a party had seen the collision from about half a block away. Their descriptions of the vehicle had been vague: dark sedan, medium size, couldn't identify make or model. But under more detailed questioning from Lawrence, one witness remembered something she'd forgotten to mention in her police interview. The driver had gotten out briefly, stood over Amy's body for a few seconds, then fled. The witness, a young woman named Keisha Thompson, had been traumatized by the scene, and her memory had been fragmented. But Lawrence's careful questioning helped her recall that the driver had seemed to be clutching his side or ribs, moving stiffly, like he was in pain. Lawrence tracked down the tow yard that had impounded my car after my arrest. The owner, a man named Vincent Morales, who'd run the yard for 32 years, had kept records of every vehicle that came through his facility. He pulled my car's file and showed Lawrence the intake photos. The damage was there: front bumper dented, headlight cracked, paint transfer consistent with striking a pedestrian. But Vincent pointed out something odd. The damage looked staged to him. In his 3 decades of experience, collision damage had a certain organic randomness to it. Impact points radiated outward in patterns that physics dictated. My car's damage looked like someone had taken a hammer to specific spots, trying to mimic collision trauma without understanding the subtleties of how metal actually deformed under vehicular impact. Lawrence photographed Vincent's analysis and moved on to Ethan's financial records. This required creative investigation since Lawrence couldn't legally subpoena anything without law enforcement backing. But people left digital trails everywhere if you knew where to look. Lawrence discovered that Ethan had made a $3,800 cash withdrawal from an ATM 3 days after the hit and run. The amount was oddly specific and large enough to suggest it was payment for something significant. Lawrence cross-referenced the withdrawal against local auto body shops, looking for cash transactions around that time frame. He found one at a shop called Precision Auto Works, a place with a reputation for discretion and cash-only repairs for people who didn't want insurance companies involved. The shop owner had died 4 years earlier, but his son who'd taken over the business remembered the transaction because of the unusual circumstances. A young guy matching Ethan's description had brought in a dark blue sedan with front-end damage, paid cash for repairs, and insisted on no paperwork. The son, Danny Suarez, had thought it was suspicious, but had been instructed by his father never to question cash customers. He'd done the work and forgotten about it until Lawrence showed up asking questions. Danny still had the car's details in his personal notes: make, model, and partial plate number. The plate matched a vehicle registered to Ethan 6 years ago, a car he'd sold shortly after my conviction. Lawrence brought all of this to a lawyer named Melissa Crane, a defense attorney with 15 years of experience handling appeals and post-conviction relief cases. Melissa reviewed the evidence with the skeptical eye of someone who'd seen plenty of wrongful conviction claims that fell apart under scrutiny. But what Lawrence had assembled was compelling enough to warrant further investigation. She agreed to take my case on contingency, meaning she'd only get paid if we won. The process of filing for post-conviction relief was complex and slow, requiring extensive documentation and legal arguments about why the original trial had been fundamentally flawed. Melissa spent 6 months preparing the petition, building a case that Ethan had not only lied in his testimony, but had actively committed the crime I'd been convicted for and had systematically framed me to escape accountability. The petition included witness statements from Keisha Thompson about the driver's injury-consistent behavior, expert analysis from Vincent Morales about the staged damage on my car, financial records showing Ethan's suspicious cash withdrawal, and testimony from Danny Suarez about the matching vehicle repair. It also included a detailed timeline showing that Ethan had motive, means, and opportunity to commit the hit and run, and that his testimony against me had been the linchpin of the prosecution's case. The hearing on my petition was scheduled for 9 months after filing. During that time, Lawrence continued investigating, finding 2 additional pieces of evidence that added weight to our case. First, he located Ethan's medical records from 3 days after the hit and run. Ethan had visited an emergency room complaining of chest pain and difficulty breathing. The diagnosis was bruised ribs consistent with blunt force trauma, specifically the kind caused by a steering wheel impact during a collision where the driver wasn't wearing a seatbelt. Ethan had told the ER doctor he'd fallen downstairs at a friend's house. Second, Lawrence found surveillance footage from the ATM where Ethan had withdrawn the $3,800. The video quality was poor, and the retention period had long passed, but Lawrence tracked down the security company that had serviced the ATM. They'd gone out of business, but the owner had kept backup archives of all footage on an external drive as part of his general paranoia about lawsuits. The footage showed Ethan at the ATM at 2:15 a.m., 3 days after the hit and run. His face was visible, showing stress and exhaustion. More importantly, his movements were stiff and careful, consistent with someone experiencing significant pain from rib injuries. The footage became Exhibit G in our petition. Judge Ronald Hastings, who'd been on the bench for 21 years, presided over the post-conviction relief hearing. He had a reputation for being thorough but skeptical of appeals, requiring overwhelming evidence before he'd consider overturning a jury verdict. Melissa presented our case methodically over 2 days, walking through each piece of evidence and explaining how it demonstrated that I'd been wrongfully convicted based on Ethan's false testimony. The prosecution fought back hard, represented by an assistant district attorney named Catherine Voss, who'd built her career on maintaining convictions even when defense attorneys discovered new evidence. She argued that the evidence Lawrence had gathered was circumstantial and speculative, that Ethan's medical records proved nothing about the hit and run, that the auto body shop testimony was unreliable hearsay from a dead man's son, that the damage analysis was one expert's opinion against the original assessment. Judge Hastings listened to both sides with an expression that revealed nothing, asking pointed questions that suggested he was taking the hearing seriously. He requested additional briefing on several legal issues and scheduled a second hearing for 6 weeks later. During those 6 weeks, something unexpected happened. Ethan's engagement fell apart. I heard about it through Rita, who'd been following his social media with the dedication of someone tracking a war criminal. Claire had apparently discovered something about Ethan that had caused her to not only break off the engagement, but also file a restraining order and move out of their shared condo in the middle of the night with help from friends. The details were unclear, but the social media posts from Claire's friends suggested betrayal and lies. Ethan's carefully constructed life was showing cracks. The second hearing brought a development that changed everything. Lawrence had tracked down Darius Webb's deceased cousin's girlfriend, a woman named Shanice Williams, who'd been dating him around the time of the hit and run. Shanice had been reluctant to talk initially, not wanting to get involved in legal matters that might expose her own past. But when Lawrence explained that an innocent man had spent 9 years in prison, she'd agreed to give a statement. She testified that her boyfriend, Anthony Williams, had known Ethan through drug connections. Anthony had sold Ethan cocaine occasionally and had mentioned that Ethan had been freaking out about hitting someone with his car. According to Shanice, Anthony had said Ethan was terrified because he'd been drunk and high when it happened, and that his family had money to make problems disappear, but he needed to pin it on someone else. Anthony had thought Ethan was paranoid and exaggerating until he'd read about my conviction, then realized Ethan had actually done it, had actually framed his own brother. Anthony had considered going to police but had been too worried about exposing his own drug dealing. The guilt had contributed to his eventual spiral into heavy drug use and overdose. Shanice's testimony was hearsay about statements from a dead man, but combined with all the other evidence, it created a compelling narrative that Judge Hastings couldn't ignore. He took another month to review everything before issuing his ruling. I was back in my cell at Danvers when Officer Dennis Kowalski came to get me, with an expression that was trying hard to stay professional, but kept breaking into something like joy. He walked me to the counselor's office where Melissa was waiting with her laptop open to the court's electronic filing system. Judge Hastings had granted my petition for post-conviction relief. He'd found that newly discovered evidence demonstrated by clear and convincing proof that I was actually innocent of the crimes for which I'd been convicted. The ruling was 38 pages long, methodically laying out how Ethan's testimony had been false, how the physical evidence had been manipulated, how the original investigation had failed to pursue obvious leads. Judge Hastings ordered my immediate release and referred the case back to the prosecutor's office for consideration of charges against Ethan for perjury, evidence tampering, and vehicular manslaughter. The recommendation was about as close as a judge could come to saying, "Arrest that lying bastard," in formal legal language. The day I walked out of Danvers Correctional Facility, I was 40 years old with 9 years of my life stolen and no clear path forward. My mother didn't recognize me when I visited her at the memory care facility. The Alzheimer's had progressed to the point where she lived entirely in the past, sometimes thinking I was her father, sometimes asking when I was going to graduate high school. Ethan had been named her legal guardian during my incarceration, which meant he controlled her finances and care decisions. That was going to change. Melissa filed an emergency petition to remove Ethan as guardian based on his criminal conduct and the conflict of interest created by his role in my wrongful conviction. The hearing was scheduled quickly, given the circumstances. Ethan showed up looking like he'd aged 20 years in the months since my release. His lawyer, a criminal defense attorney named Robert Finch, who specialized in representing wealthy defendants in serious cases, argued that Ethan's guardianship had been exercised appropriately and that my allegations about his testimony were still under investigation. The judge, a woman named Diana Southworth who'd spent 18 years in family court, reviewed Judge Hastings' ruling and Melissa's petition with a stern expression that suggested she'd already made up her mind. She removed Ethan as guardian immediately, appointed a temporary professional guardian until I could petition for the role, and ordered Ethan to provide a full accounting of all financial transactions involving our mother's assets. The look on Ethan's face when Judge Southworth announced her decision was the first moment of genuine satisfaction I'd experienced since my release. The district attorney's office took 4 months to decide whether to charge Ethan. The new DA, a man named William Foster, who'd been elected on a criminal justice reform platform, assigned the case to a senior prosecutor named Angela Ramsey. She'd spent 23 years handling major crimes and had a reputation for being tough, but fair. Angela met with me, Lawrence, and Melissa to review all the evidence and discuss the strengths and weaknesses of a potential case against Ethan. The challenges were significant. Most of the evidence was circumstantial. Shanice's testimony was hearsay. The medical records and auto body shop repairs proved Ethan had been in a collision around the right time, but didn't definitively prove it was the same collision that killed Amy Thornton. The staged damage on my car suggested tampering, but couldn't be conclusively linked to Ethan. A defense attorney like Robert Finch would poke holes in everything, create reasonable doubt, potentially get Ethan acquitted, just like I'd been convicted. Angela explained this with the weary honesty of someone who'd seen strong cases collapse and weak cases result in convictions, all based on factors that had little to do with actual guilt or innocence. But she also said that sometimes prosecutors had to take difficult cases to trial because the alternative, letting someone walk away from serious crimes, was worse than the risk of losing. She recommended charging Ethan with vehicular manslaughter, leaving the scene of an accident, perjury, obstruction of justice, and evidence tampering. The DA approved the charges a week later. Ethan's arrest happened at his office on a Thursday morning, exactly 9 years and 3 months after my own arrest. Lawrence had tipped off a journalist named Michelle Navarro, who'd been covering wrongful conviction cases for the regional newspaper. Michelle was there with a photographer when police led Ethan out in handcuffs, his face a mask of shock and humiliation. The photo made the front page the next day with a headline that read, "Brother accused of framing sibling for fatal hit and run." The article detailed the evidence against Ethan and the timeline of my wrongful conviction and eventual exoneration. Public reaction was swift and brutal. Ethan's employer placed him on administrative leave within hours of the arrest. His remaining friends began distancing themselves publicly. Social media picked up the story, and suddenly everyone who'd watched me get convicted was confronting the possibility that they'd witnessed a spectacular injustice. The comments sections filled with outrage at the system that had failed me and at the brother who'd betrayed me so thoroughly. Ethan made bail at $500,000, posted by his father-in-law-to-be from his broken engagement. Apparently, Claire's father believed in Ethan's innocence, or at least in hedging his bets. Robert Finch held a press conference declaring Ethan's innocence and claiming that the charges were based on vendetta and circumstantial evidence. He painted me as a wrongly convicted man who'd fixated on blaming his brother instead of accepting that the original investigation had simply made mistakes. The strategy was bold, but flawed, because it required ignoring Judge Hastings's detailed ruling and the mountain of evidence Lawrence had compiled. The trial was scheduled for 8 months out, giving both sides time to prepare. Angela's prosecution was methodical and thorough, building the case piece by piece with the same attention to detail I'd once applied to financial investigations. She brought in experts to testify about the staged damage on my car, about collision physics, and how Ethan's injuries matched steering wheel impact. She walked the jury through Ethan's financial records, his suspicious cash withdrawal, the auto body shop repair. She presented Keisha Thompson's recollection of the injured driver, Shanice Williams's testimony about Anthony's statements, and the timeline showing Ethan's motive to deflect blame. The evidence of Ethan's perjury at my trial was particularly damning. Angela played excerpts of his testimony where he'd claimed I'd confessed to him, where he'd described my supposed agitation and guilty behavior. She contrasted that with the evidence showing it was Ethan who'd been injured, Ethan who'd had his car repaired, Ethan who'd needed to pin the crime on someone else before investigators looked too closely at him. Robert Finch fought back with everything he had. He attacked the credibility of every witness, suggested that the evidence was being reinterpreted to fit a narrative, argued that Ethan had no motive to frame me when he could have simply stayed silent. He brought character witnesses who testified to Ethan's good nature and honesty. He suggested that the real story was that I'd committed the hit and run, that Ethan had reluctantly testified truthfully, and that now I was using circumstantial evidence to take revenge on the brother who'd done his civic duty. The prosecution's case took 3 weeks to present. Angela was relentless, building layer upon layer of evidence that pointed to Ethan's guilt and my innocence. She brought in forensic experts who'd reviewed the original investigation and found it shockingly inadequate. She presented evidence that the detective who'd taken Ethan's statement, Lawrence Chen, had failed to follow up on obvious inconsistencies and had accepted Ethan's testimony without question. She showed that the damage assessment on my car had been cursory and potentially manipulated. Lawrence Boone testified about his investigation and the patterns he'd uncovered. He explained how Ethan's behavior after the hit and run was consistent with someone trying to cover up his own crime rather than someone who'd witnessed his brother confess. The medical records showing Ethan's injuries, the timeline of the auto body repair, the suspicious financial transactions, all of it pointed to a deliberate frame-up rather than a tragic accident. Rita Kowalski testified about my behavior during incarceration, explaining that in her 18 years working in the prison library, she'd seen plenty of guilty inmates maintaining their innocence. But she'd also developed a sense for who was genuinely wronged versus who was simply in denial. She said I'd never wavered in my story, never shown the inconsistencies that liars eventually revealed, and had spent years methodically documenting evidence while others would have given up. Ethan took the stand in his own defense, a decision that Robert Finch almost certainly regretted. Under direct examination, Ethan maintained that he'd told the truth at my trial, that I'd seemed agitated and had made comments that suggested guilt. He couldn't explain the evidence of his own injuries or the auto body repair, except to say that he'd been in a minor accident around that time that he'd forgotten about. He claimed the timing was coincidental. Angela's cross-examination was devastating. She walked Ethan through every detail of his testimony at my trial, then confronted him with evidence that contradicted each claim. When he said he couldn't remember specifics about his own injuries, she presented the ER records with precise details. When he claimed the auto body repair was for minor damage, she showed photos of collision-level destruction. When he tried to explain away the cash withdrawal, she presented the timeline showing it occurred exactly 3 days after the hit and run. Most damning was when Angela asked Ethan directly, "Did you let your brother go to prison for 9 years to protect yourself?" Ethan's face did something complicated. Anger and fear and guilt all fighting for dominance. He said no, but the word came out weak and unconvincing. Angela pressed harder, walking him through each piece of evidence, each suspicious timing, each convenient coincidence. By the end of her cross-examination, Ethan looked small and trapped, his earlier confident denials replaced by defensive evasions and memory lapses. The jury deliberated for 26 hours across 3 days. I sat in the courthouse hallway with Melissa, Lawrence, Rita, and Officer Kowalski, all of us existing in a strange, suspended state between hope and dread. My entire future depended on whether 12 strangers believed the evidence or bought Robert Finch's alternative narrative. When the jury returned, their faces told the story before the foreman spoke. They'd found Ethan guilty on all counts: vehicular manslaughter, leaving the scene, perjury, obstruction of justice, evidence tampering. Every single charge had stuck. Ethan's face went white, then red, his mouth opening and closing without sound. Robert Finch immediately started talking about appeals. The judge ordered Ethan remanded into custody pending sentencing, which meant he'd spend the next few weeks in the same jail system where I'd spent 9 years in prison because of his lies. Sentencing happened 6 weeks later. Amy Thornton's mother was there, looking older and more fragile than I remembered from my own trial. She gave a victim impact statement that was different from the one she'd given 9 years earlier. This time, she talked about how the original conviction had felt hollow to her, how something about it had never sat right, even though she desperately wanted someone held accountable for her daughter's death. She said learning the truth had reopened wounds she'd tried to heal, but that knowing the actual person responsible was being held accountable provided closure she'd never gotten from my conviction. She looked at Ethan and asked him the same question she'd asked me years ago. Why had he stolen her daughter's future? This time, the question landed on the guilty person. I gave my own statement, describing the 9 years I'd lost to wrongful imprisonment, the damage to my relationship with my dying mother, the career I'd built that had been destroyed, the life I'd had planned that had disappeared. I talked about the betrayal of having my own brother lie under oath to save himself, about watching him build a life on the foundation of my destroyed one, about the system that had believed him without question and had nearly cost me everything. I said, I didn't want revenge. I wanted accountability. I wanted Ethan to face the consequences he'd let me endure while he'd lived freely. Judge Patricia Winters, who'd been on the bench for 17 years and had a reputation for thoughtful sentencing, listened to everything without interruption. When everyone had finished speaking, she addressed Ethan directly. She said his crimes weren't just about the hit and run, though that alone was serious enough. They were about the systematic betrayal of his brother, the perjury that had condemned an innocent man, the years of watching that injustice continue without coming forward. She said the court system depended on truthful testimony, and Ethan had corrupted that system for nearly a decade to save himself. She sentenced him to 18 years for the vehicular manslaughter, consecutive sentences for the obstruction and evidence tampering charges, bringing his total sentence to 24 years with possibility of parole after serving 85%. Ethan would be in his mid-50s before he'd be eligible for release. The sentence was harsh, but proportional to the harm he'd caused, not just to Amy Thornton and her family, but to me and to the integrity of the justice system itself. Ethan was led away in shackles, his face blank with shock. Robert Finch was already talking about grounds for appeal, but Judge Winters' sentencing had been careful and well supported. The appeals would likely fail just like mine had, because this time the evidence and the verdict aligned with actual truth. I walked out of the courthouse into afternoon sunlight that felt different from every other day since my arrest 9 years earlier. Michelle Navarro approached with her recording device and asked how I felt about the verdict and sentence. I told her I felt validated, but not victorious. 9 years of my life were still gone. My mother would never recover from her Alzheimer's enough to understand what had happened. The career I'd built was a distant memory. Justice had been served, but it couldn't restore what had been taken. She asked what I'd do now. I said I was going to rebuild, advocate for wrongful conviction reform, and make sure other people didn't lose years to a system that believed lies without sufficient scrutiny. The wrongful conviction settlement took 18 months to negotiate. The state offered $50,000 per year of wrongful imprisonment, plus legal fees, a total of $565,000 after Melissa's contingency fee and expenses. It wasn't enough to replace 9 years of lost earnings, career advancement, and life experiences, but it was enough to start over. I used part of the settlement to establish a foundation focused on wrongful conviction cases and investigation funding for people who couldn't afford private investigators like Lawrence Boone. I named it the Amy Thornton Justice Foundation, with her mother's blessing. Mrs. Thornton joined the board and became a powerful advocate for thorough investigation before conviction. We partnered with journalism programs to train investigative reporters, with law schools to provide clinical experience in post-conviction relief cases, and with retired law enforcement officers who wanted to use their expertise to uncover truth rather than just close cases. Lawrence Boone became the Foundation's lead investigator, his salary finally allowing him to focus full-time on the work he was most passionate about. Rita Kowalski retired from her prison library position and joined as our research director, bringing her decades of experience identifying genuinely innocent inmates versus those gaming the system. The Foundation took on its first case within 6 months, a woman who'd been convicted of arson based primarily on testimony from her ex-husband who'd had financial motive to destroy their shared property. Lawrence's investigation uncovered evidence that had been overlooked or suppressed, and within a year, we'd helped get her conviction overturned. I went back to school for a law degree, something I'd considered before my wrongful conviction derailed my life. This time, I had focus and purpose beyond just career advancement. I wanted to understand the system that had failed me well enough to change it from the inside. My classmates were mostly in their 20s, viewing me as the older student with an unusual story. Few knew the details until I gave a guest lecture in a criminal law class about wrongful convictions. Speaking about my experience to future lawyers felt like turning pain into purpose. My mother passed away in my 3rd year of law school. The Alzheimer's had progressed to the point where she no longer recognized anyone or responded to stimuli. I'd visited her weekly, despite knowing she didn't know who I was, sitting beside her bed and talking about my foundation work and my studies. Some part of me hoped that hearing my voice provided comfort, even if she couldn't consciously recognize it. Her funeral was small, just me, a few of her friends from before her diagnosis, and some staff from the memory care facility who'd grown fond of her. Ethan requested permission to attend from prison. I denied the request. He'd stolen 9 years of my life and had robbed our mother of knowing her son was free and vindicated. He could grieve from his cell. I graduated law school at 43 and passed the bar exam on my first attempt. The character and fitness review for bar admission required extensive documentation about my criminal record and subsequent exoneration. The committee spent 6 months reviewing my case before approving my application, noting that my wrongful conviction and subsequent advocacy demonstrated exactly the kind of character the legal profession should embrace. I joined a criminal defense firm specializing in appeals and post-conviction relief, bringing my forensic accounting background and personal experience to cases where financial evidence might unlock wrongful convictions. Ethan became eligible for parole after serving 21 years of his 24-year sentence. He'd been a model prisoner according to reports, participating in educational programs and maintaining good behavior. His parole hearing was scheduled on a Wednesday morning in late fall. I submitted a written statement opposing his release, but I also attended in person to deliver my victim impact statement. Ethan looked old and broken when they brought him into the hearing room. Prison had aged him more severely than it had aged me, or perhaps the weight of guilt wore harder than the burden of injustice. His hair had gone gray, his face was lined and hollow, and he moved with the careful slowness of someone who'd spent too long in an environment where sudden movements could be dangerous. The parole board asked him about his crimes and his rehabilitation. Ethan gave what sounded like a prepared statement about taking full responsibility for his actions, about the years he'd spent reflecting on the harm he'd caused, about his remorse for letting me go to prison while he'd lived freely. It was the first time I'd heard him actually acknowledge what he'd done without equivocation or excuse. The board asked if he had anything to say to me directly. Ethan turned in his chair to face me across the hearing room. He said, "Jordan, I'm sorry doesn't even begin to cover what I did to you. I was scared and selfish, and I convinced myself that you'd be fine, that the evidence wouldn't be enough to convict you, that someone would figure out the truth before it went too far. When you were convicted, I told myself I'd come forward eventually, but every day made it harder. Every year made it more impossible. I destroyed your life to save mine, and there's no apology that makes that okay." His voice broke on the last sentence. It was the most honest thing he'd said to me in 30 years. I gave my statement about the ongoing impact of his crimes, the 9 years I'd lost, the career I'd had to rebuild from nothing, the relationship with our mother I'd never gotten back, the trust in family that had been permanently shattered. I talked about how his choices had created ripples that still affected me daily, how I still had hypervigilance from prison that made normal social situations uncomfortable, how I still woke up sometimes believing I was back in a cell at Danvers. I said I didn't forgive him and might never be able to, but I also said I didn't need him to stay in prison for my own healing. If the board believed he was rehabilitated and no longer a danger to society, they should make their decision based on that assessment rather than on my desire for prolonged punishment. The parole board deliberated for 40 minutes before announcing their decision. They'd grant parole with conditions. Ethan would be on supervised release for 3 years, required to continue therapy, prohibited from contact with me or Amy Thornton's family without permission, and mandated to perform 500 hours of community service speaking to at-risk youth about the consequences of his choices. Ethan would be released within 30 days. I felt nothing watching him process the decision. No satisfaction, no anger, just a strange emptiness where my desire for revenge had once lived. Justice had been served. Ethan had faced consequences. The system had eventually, belatedly, gotten it right. But 9 years were still gone, and no amount of his imprisonment would return them. 10 years after my release from Danvers, I was giving a keynote speech at a criminal justice reform conference in Chicago. The Amy Thornton Justice Foundation had helped overturn 43 wrongful convictions, trained hundreds of investigators and attorneys, and had become a model for similar organizations across the country. My legal practice had argued successfully for post-conviction relief in cases that other lawyers had deemed hopeless. Mrs. Thornton introduced me at the conference, talking about how her daughter's death had led to both injustice and eventually to systematic change. She called me a friend and an inspiration, which still felt surreal, given that we'd first encountered each other at my wrongful conviction trial. During the Q&A after my speech, someone asked if I'd ever reconciled with my brother. I said no. Ethan had been released from prison 3 years earlier and was living quietly in another state, working in construction and apparently staying out of trouble. We had no contact, and I had no plans to change that. Some betrayals were too fundamental to overcome, some relationships too damaged to rebuild. The questioner asked if that bothered me. I said it used to, but I'd learned that healing didn't require forgiveness, and moving forward didn't require reconciliation. I'd built a life that had meaning and purpose beyond my trauma. That was enough. Lawrence Boone approached me after the session ended, holding his phone out with an email pulled up. One of his old detective contacts had reached out about a case that had parallels to mine, a woman convicted of embezzlement based primarily on testimony from her business partner who'd had access to all the same accounts. The investigation had been surface level, the conviction had come quickly, and the woman was now 7 years into a 12-year sentence. Lawrence wanted to know if the foundation would take the case. I read through the preliminary details and felt the familiar pull of a pattern that shouldn't be ignored. I told Lawrence to start the investigation, to pull together everything he could find, to look for the evidence that the original investigation had missed. That's what we did now. We found the truth that others had been too rushed or too biased to seek. We gave people back their lives when the system had stolen them. I walked out of the conference center into evening air that smelled like lake water and autumn leaves. My phone buzzed with messages from my staff about other potential cases, from reporters wanting interviews about wrongful conviction reform, from law students wanting advice about careers in criminal defense. I had built something meaningful from the wreckage of my wrongful conviction. Ethan had taken 9 years of my life, but he hadn't been able to take my capacity to fight for justice or my refusal to let injustice win. Some stories don't end with neat resolution or perfect closure. Some stories end with survival and purpose and the determination to make sure fewer people have to experience what you experienced. Mine ended with the knowledge that the brother who'd betrayed me was living with the consequences of his choices while I was living with the meaning I'd built from mine. And in the strange accounting of justice and healing, that felt like enough. Thanks for watching till the end. Make sure to subscribe and like to not miss the next story.